Good day everyone, welcome back to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an employee is manipulated to conclude a mutual separation agreement. What are the applicable legal considerations and implications? This was the issue the Labour Court had to determine in the matter of WBHO Construction Proprietary Limited versus Masanya and others. Mr. Mdai, the employee, commenced his employment with WBHO, the company, in 2018. In 2020, he was approached by a representative of the company during a site visit. It was during this time that the representative had discussions with the employee regarding the company's operational requirements. During this discussion, the employee was asked whether he would transfer to the Northern Cape, where the company required his services, but he refused. Notwithstanding that the discussions between the representative and employee were concerning the company's operational requirements, which obviously invoke Section 189 of the Labour Relations Act, the parties concluded and signed what is termed a mutual separation agreement. The signed document, which purported to be a mutual separation agreement, contained terms of retrenchment. The terms of the agreement recorded that, following recent consultations between the parties, the employee was to be retrenched and would receive a severance package. The mutual separation agreement further recorded that the employee hereby acknowledges and accepts the above retrenchment in full and final settlement of all or any claims that I as an employee may have. The employee subsequently referred an unfair dismissal dispute to the bargaining council and argued that he had been misled into signing the agreement and that it was signed under misrepresentation and duress. The panelists found that no retrenchment process had been followed, the employee had been pushed or dismissed, and that there was no reason to terminate the employee's services. Accordingly, the employee's dismissal was found to be both procedurally and substantively unfair. The company took the matter on review to the Labour Court. The Labour Court found that the company had an intention to retrench the employee prior to signing the mutual separation agreement. During the meeting between the representative and employee relating to discussions concerning the company's operational requirements, the employee revealed his financial challenges to the representative. It appeared that instead of the company following the procedure concerning dismissals based on operational requirements as per Section 189 of the Labour Relations Act, the company took advantage of the employee's ensuing financial challenges and lured him into a mutual separation agreement. Instead of complying with Section 189, the company chose a convenient way of circumventing the provisions of Section 189 by signing a retrenchment document masked as a mutual separation agreement with the employee, which agreement clearly indicated that the employee was retrenched. The court found that based on the employee's argument that he was misled and that there was a misrepresentation, the parties are not in agreement as to the terms of the mutual separation agreement, and the mutual separation agreement should be ignored. In particular, the court held that while the employer presented a retrenchment document, that had the language of a retrenchment to the employee, the document was signed as a mutual separation, and when the employee signed the mutual separation agreement, his intention was not to be retrenched. The Labour Court held that the company cannot use a mutual separation agreement to circumvent the provisions and procedures set out in Section 189 of the Labour Relations Act. The company defeated the objects of Section 189 by disregarding its discussion concerning its operational requirements and signing a mutual separation agreement containing terms of retrenchment. The court held that once it had a discussion with the employee concerning its operational requirements, the company was obligated to follow the procedure in Section 189. Ultimately, the company's review application failed and it had to pay the employee's costs. A key takeaway from this case is that in circumstances where a company confronted with operational requirements necessitating retrenchments pursues the termination of an employee's employment by either mutual agreement or by way of a voluntary retrenchment agreement, it is sensible to commence the Section 189 consultation process first. Colleagues, that brings us to an end of this week's episode. Thank you for joining us. We hope that you have found our discussions informative. If you have any questions, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, bye-bye.